Welcome to The Explainer. Today, we're going to talk about one of the most important legal cases of all time. And it all started with, believe it or not, a snail in a bottle.
I know it sounds pretty absurd, but this one single bizarre incident really did change everything. It literally laid the foundation for the entire modern law of negligence. It forced the courts to ask a really fundamental question. When someone gets hurt, who's actually responsible? And to understand why that question was so tough to answer, you first have to understand what the law looked like before the snail came along.
Okay, so let's set the scene, because the details here are so specific and, frankly, a little bit ridiculous that they make the story incredibly powerful. This is the true story of a shop assistant named May Donoghue.
So picture this. It's a summer evening back in 1928 in Paisley, Scotland. May Donoghue is at a cafe with a friend. Her friend kindly buys her an ice cream float made with Stevenson's ginger beer. Now, the key thing here is that the bottle was made of dark, opaque glass, so you couldn't see what was inside. May drank some of it, and then her friend went to pour the rest into her glass, and out plopped the remains of a decomposed snail. As you can imagine, she went into shock and later developed severe gastroenteritis, which left her unable to work.
The actual legal filing is just so vivid. It doesn't just say there was a snail, it describes how it floated out in a state of decomposition. Her lawyers were trying to paint a picture. They argued this wasn't just some freak accident, it was systemic carelessness. They claimed the factory's bottle washing system was faulty and that snails had an, quote, freedom of access to the bottles. They were arguing negligence, plain and simple. So May Donoghue, a woman who swore she had less than 5 pounds to her name, sued the manufacturer, Mr. Stevenson, for 500 pounds. Now, that was a massive amount of money back then, like 2 full years of wages. For her, this wasn't just about some gross-out moment. It was what she called a social wrong that had turned her life upside down. But legally speaking, her case looked pretty much dead in the water. Okay, so why was her case so hopeless? Let's get into the legal maze she was facing. You see, before this whole snail incident, the law had this huge gap, a blind spot, that basically left people like May with no way to get justice from the person who was actually at fault. It all came down to this legal idea called privity of contract. And what it means is pretty simple. You can only sue someone you have a direct contract with. Think about it. May's friend was the one who bought the ginger beer, so May herself had no contract with the cafe. And she certainly didn't have a contract with the manufacturer, Mr. Stevenson. So as far as the law was concerned, she was a complete stranger to the whole transaction. And this right here, this lays out the legal trap perfectly. Back then, a manufacturer could only be held liable in 3 very specific situations. 1, you had a contract with them. 2, the product was just dangerous in itself, like a gun or poison. Or 3, they committed fraud by knowingly hiding a defect. May's case didn't fit any of these. No contract. Ginger beer is not a weapon, and the manufacturer didn't knowingly put that snail in that bottle. The law gave her absolutely no path to a remedy. But her case kept going, all the way up to the House of Lords in London, the highest court in the land. It was on the verge of being thrown out. But then, a razor-thin 3-2 decision changed everything. This is the breakthrough. The court was completely split. On one side, you had Lord Buckmaster, who was defending the old way of thinking. He was terrified of opening the floodgates of lawsuits. He thought if they sided with May, then any manufacturer of any product could be sued by anyone. And he called that an absurd and logically impossible outcome. But then you had Lord Atkin. He just couldn't accept that such an obvious social wrong had no legal fix. He wanted to look past the old rigid rules and focus on the real relationship between the company making the product and the person using it. And this is the revolutionary part. Lord Atkin asked this incredibly simple but profound question. Who, in law, is my neighbor? And then he answered it himself, brilliantly turning a moral concept into a legal one. He said, your neighbor isn't just the person living next door. Your neighbor is anyone so closely and directly affected by your actions that you should reasonably have them in mind when you act. In other words, a manufacturer's duty doesn't just stop at the factory gate. It extends all the way to you, the final consumer. So here's how this neighbor principle breaks down. First, Lord Atkin created a whole new foundation for liability. It's not about contracts anymore, it's based on a general public sentiment of moral wrongdoing. He took that moral rule, love thy neighbor, and turned it into a legal one. You must not injure your neighbor. Then he defined that neighbor. It's anyone you can reasonably see might be hurt by what you do. He called this proximity, not in a physical sense, but about having a close and direct relationship, just like the one between a company and the person who ends up with their product. It just swept all the old, confusing categories away.
So, to what extent did this really change tort law? Well, the impact wasn't just big. It was immediate and absolutely seismic. That one little snail didn't just create a new rule for bad ginger beer, it became the cornerstone of all modern negligence law.
You see, the real power of this new principle was how flexible it was. The ripple effect was incredible. Just a few years later, in 1936, it was used in a case where a man got dermatitis from chemicals that were carelessly left in his underpants. By 1964, it was expanded to cover financial loss from bad advice. Since then, it's been used to figure out the duties of everyone from accountants to government bodies. It basically created a whole new framework for responsibility in our modern world. Another one of the judges in that 3-2 majority, Lord Macmillan, said something that perfectly captured the spirit of the whole thing. He said, "The categories of negligence are never closed." And what he meant was, this wasn't about creating one last final rule. It was about creating a living principle, one that could grow and adapt as our society changes.
So even now, all these decades later, this case still sparks debate. The snail's legacy isn't just some dusty legal rule. It's this ongoing conversation about what the law is even for. One scholar, Julia Stone, had a really interesting take. He argued that the judges in this case weren't just finding some hidden rule in the law. He said they were using what he called leeways of choice, basically using the flexibility in legal reasoning to arrive at a policy outcome they personally thought was right. It suggests the decision was a very conscious, deliberate choice to drag the law into the modern world and make manufacturers responsible for what they produce.
And really, this is the core tension the case left us with, a tension that still exists in law today. On one side, you have Lord Buckmaster's view, which prioritizes certainty, the idea that we need clear, rigid rules so businesses know where they stand. But on the other side, you have Lord Atkin's view, which values flexibility and justice, the belief that the law has to adapt to protect people who are vulnerable. And that fundamental conflict, it continues to shape legal decisions all the time.
Which brings us to this final thought from a modern judge who wondered, all of this leads me to wonder, where on earth May Donoghue's Snail is off to now? And that just captures it perfectly, doesn't it? A single decomposed snail set the law off on this incredible journey of evolution that is still going on. And as our world gets more and more complex, it keeps forcing us to ask Lord Atkin's revolutionary question over and over again. In this world right now, who is my neighbor?